In the intricate tapestry of legal proceedings, where the narratives of corporate giants intersect with the principles of justice and equity, Apple finds itself at the epicenter of a sprawling legal saga of unprecedented magnitude and complexity. Set against the backdrop of London's venerable halls of justice, this titanic clash unfolds as the tech titan grapples with a formidable coalition comprising over 1,500 app developers, each a protagonist in their quest for fairness and accountability within the expansive domain of Apple's App Store. At the forefront of this monumental legal odyssey stands Sean Ennis, a towering figure revered for his erudition in the realms of competition law and economics. With an unyielding commitment to upholding the tenets of justice and a steadfast resolve to champion the rights of the marginalized, Ennis leads the charge on behalf of the beleaguered developers, navigating the intricate labyrinth of legal complexities with a blend of scholarly acumen and impassioned advocacy. Central to the contentious dispute lies the issue of App Store fees, a contentious levy imposed by Apple, which extracts a substantial portion of developers' earnings and is perceived by many as a barrier to innovation and a hindrance to fair competition. This levy serves as the focal point of Ennis' crusade for reform, as he endeavors to dismantle the monopolistic structures that underpin Apple's digital empire and pave the way for a more equitable distribution of resources within the app ecosystem. However, Apple, fortified by its vast resources and formidable legal arsenal, mounts a vigorous defense, deploying a phalanx of high-priced attorneys to safeguard its corporate interests and preserve its dominance within the digital marketplace. Through a strategic combination of legal maneuvering and rhetorical flourish, the tech behemoth seeks to deflect allegations of impropriety and shield itself from the specter of legal culpability. As the legal proceedings unfold with the weight of historical precedent and the urgency of contemporary relevance, the courtroom becomes a crucible wherein the principles of justice and corporate accountability converge in a symphony of scrutiny and debate. With each legal argument and counterargument, the fate of Apple hangs in the balance, poised at the precipice of accountability or absolution, depending on the outcome of the judicial deliberations. In a dramatic twist of fate, Judge Andrew Lenon delivers a momentous ruling, striking a resounding blow against Apple's legal defenses and affirming the validity of Ennis' claims. With a meticulous dissection of legal precedent and a judicious application of jurisprudence, Judge Lenon elucidates the implications of Apple's alleged overcharging of UK-based developers, asserting the jurisdictional authority of British law in adjudicating matters of corporate conduct. As the echoes of Judge Lenon's ruling reverberate through the hallowed halls of legal discourse, the ramifications of this historic decision extend far beyond the confines of the courtroom. Indeed, the outcome of this epical legal saga serves as a clarion call for reform within the digital ecosystem, a harbinger of change that heralds a new era of accountability and transparency in the realm of tech governance. And so, as the world watches with bated breath, the denouement of this legal saga unfolds, a climax wherein the forces of justice and corporate power collide in a battle for the soul of the digital age. In this crucible of legal conflict, the destiny of Apple, and the very future of the tech industry itself, hangs in the balance, awaiting the final verdict of justice's unforgiving gaze.